Section 4, decisions about naming an education provider. Section I, as we've heard before, relates to placement. It must state the name and type of school or a type where the name is not yet known. And this is going to be the school or institution to be attended by the child or young person. These details are only included in the final Education, Health and Care Plan. The draft EHC plan must be blank at Section I when it's sent to parents and carers or the young person, although this doesn't mean that discussions can't take place about placement prior to that point. It's important to note that the local authority has a duty to consult with certain schools, institutions and local authorities. The local authority has to consult the governing body of the school or other institution that a parent or young person requests. And if that school or institution is in another local authority, then the local authority has to consult this other local authority. The educational institution should respond to the consultation within 15 calendar days, and this is set out in the Code of Practice. But the local authority whose decision it is can proceed to make that decision in the absence of any response after those 15 days. Where a parent or young person wants a school of the type set out in Section 38(3) of the Act, the local authority has a conditional duty to name the school requested. The types of school that this applies to are maintained nursery schools, academies, maintained schools, which may be mainstream or special schools, an institution within the FE sector, a non-maintained special school, or an institution approved by the Secretary of State under Section 41. These are schools that tend to be independent schools that are registered with the Secretary of State, and they can be found by looking them up on the DfE website. These are the types of school or college which can be requested, and unless the local authority can establish one of the following 3 conditions, they must be named. The legal test which sets out these conditions is in Section 39(4), and the exceptions are A, that the school requested is unsuitable for the age, ability, aptitude or SEN needs of the child or young person concerned, or the attendance of the child or young person at the requested school or other institution would be incompatible with either the provision of efficient education for others or the efficient use of resources. Some of the commonly given but unlawful reasons for refusing to name are: the school is in another local authority, or the school is full, or that there is a nearer suitable school, that the school is too academic, that the child or young person doesn't fit the profile of the other pupils, or that the child or young person is fine where they are. The right to a mainstream education is set out in Section 33 of the Act. And this says that a child or young person must be educated in a mainstream school or institution unless the parent or young person doesn't wish it, or it's incompatible with the provision of efficient education of other children, and there are no reasonable steps that can be taken to prevent this. It's important to note that under this section of the Act, suitability or the efficient use of resources are not relevant considerations. What happens where a parent or a young person wants an independent school? In these circumstances, there's a duty on the local authority to have regard to the general principle that pupils are to be educated in accordance with the wishes of their parents, so far as that's compatible with the provision of efficient instruction and training and the avoidance of unreasonable public expenditure. An unreasonable public expenditure looks at all public expenditure, not just the expenditure of the local authority. In the leading case, Hammersmith and Fulham, on the facts, it was found that a difference of £11,500 was not necessarily unreasonable public expenditure, but this decision will be made on the individual facts of any case. It's important to also remember that young people still have the right to ask for an independent school, but the local authority is not obliged to name this under Section 39(4). and instead we will be looking at section 42 of the Act.